She sued her mom's caretaker for $340,000 3 weeks after the funeral. She watched her mother take her last breath, and 3 weeks later, she filed a lawsuit for $340,000 against the one person who had been there at the end. The plaintiff was a woman in her mid-40s, the eldest of 3 siblings, and by her own account, the responsible one. She had managed the family finances for years, held power of attorney during the difficult final months, and believed she knew exactly what her mother's estate looked like. She and her mother had discussed it: the accounts, the property, the inheritance divided equally among the children. After the funeral, when she sat down with the estate attorney and began tallying the numbers, one account was nearly empty, a savings account that, as recently as 8 months prior, had held $340,000. The family doctor had been her mother's physician for 11 years. He was 63, soft-spoken, the kind of doctor who still made house calls and remembered his patients' birthdays. In the final 14 months of the mother's life, as her dementia progressed, he had become a frequent presence, adjusting medications, coordinating with specialists, occasionally sitting with her simply because the nursing staff was stretched thin and she became distressed without a familiar face. The plaintiff found this devotion, in retrospect, suspicious. The plaintiff's argument was straightforward and brutal. Her mother had been cognitively vulnerable. The doctor had access. He had cultivated an unusually close relationship with a woman who no longer fully understood what she was signing. Bank records showed 14 withdrawals totaling $340,000 over an 11-month period, all of them made in person at the bank branch closest to the medical clinic. Her mother, in the late stages of dementia, could not have navigated that independently. Someone had assisted her. Someone had benefited. The doctor denied everything. His attorneys presented a man visibly wounded by the accusation. He had dedicated his career to elderly patients precisely because he believed they deserved dignity and consistency. He acknowledged driving the mother to appointments on 2 occasions when her regular transport fell through. He acknowledged their closeness. He denied, categorically, ever accompanying her to a bank, ever discussing her finances, or ever receiving a single dollar. His bank records, voluntarily submitted, showed no unusual deposits or transfers. His lifestyle had not changed. He drove the same car he had owned for 9 years. Then the bank released its security footage: 14 visits, 14 recordings. The footage was time-stamped, clear, and consistent. In every single instance, the elderly woman arrived at the branch accompanied by the same person. And it was not the doctor. It was the plaintiff's younger brother, the quietest of the 3 siblings, who lived 40 minutes away and had, by his own previous statements to the estate attorney, claimed he had rarely visited his mother in her final year due to work obligations. The brother had never been named in the lawsuit. The plaintiff's own attorney had to request a recess. Over the next 11 days, the case collapsed and reconstructed itself entirely. The brother, when confronted, initially claimed the withdrawals were at his mother's explicit direction, that she had wanted to gift him money she feared the estate attorney would misallocate. He had no documentation, no written instructions, no witnesses. What he had was surveillance footage of himself guiding a confused, frail woman to a teller window 14 times while she signed forms she almost certainly did not understand. The judge dismissed the case against the doctor with prejudice. In her ruling, she noted that the plaintiff had pursued the claim with genuine belief but insufficient investigation, and that the emotional weight of grief was not, on its own, a substitute for evidence. She recommended the matter be referred to the district attorney's office, which it was. The brother ultimately entered a plea agreement on financial elder abuse charges and was ordered to repay the full $340,000 to the estate, structured over 7 years, along with $18,500 in legal costs. The doctor never returned to practicing at the same clinic. He retired 14 months after the case concluded. Those who knew him said the lawsuit had not destroyed his reputation so much as his willingness to go the extra mile. The house calls, the late evenings, the small kindnesses that had once defined him. He told a colleague he simply couldn't afford to care that much anymore. The plaintiff and her brother have not spoken since the plea agreement was entered. Whether she blames herself for pointing the finger in the wrong direction or blames him for putting her in that position, no one outside the family knows for certain. The money was partially recovered, the relationship was not, which raises the question that lingers long after the gavel falls. When grief makes us certain we know who the villain is, are we searching for the truth, or are we searching for someone to blame?